This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court has refused to allow President Trump to immediately oust Federal Reserve Governor Lisa Cook over mortgage fraud allegations she's denied. The order issued today with no dissents means Cook can remain in her position at least until the justices rule, and oral arguments in the case aren't even scheduled until January. The Supreme Court has largely sided with Trump this year in cases challenging his firings of officials at different federal agencies. So today's order was rare. Joining me is Elliott Stein, Bloomberg Intelligence Senior Litigation Analyst. Elliott, is this a big win for Cook?
I would say it's a interim win for her because it does allow her to stay in her position as a Federal Reserve Board governor while the case continues to proceed in the Supreme Court. But the Supreme Court didn't really weigh in further than that, and it said that it has deferred any ruling for now until after it can hear oral argument in January of 2026. So she will be serving in her current role until then at a minimum, and then we'll wait to see what the justices say beyond that.
The Supreme Court has basically sided with Trump this year in cases challenging his firing of officials at different federal agencies. For example, the firing of the FTC commissioner, the firing of the NLRB board member, and the firing of the Merit Systems Protection Board member. And the court has allowed the removal of those officials as the litigation plays out. So does this say the Supreme Court sees the Fed differently?
Yeah, absolutely. I think that's exactly right. We've seen so many cases, including the ones that you mentioned, brought by commissioners of other agencies that President Trump fired. They sued. Those cases mostly went in the commissioners' favors in the lower courts. And then when it got to the Supreme Court, the justices usually on either an administrative basis or on an emergency stay application essentially overruled the lower courts and allowed the terminations to take place and take effect while the litigation played out. This is very notable because the Lisa Cook case really is different in that respect. First, Justice Roberts did not issue an administrative stay like he did just a couple weeks ago in the FTC case involving Rebecca Slaughter. And then he referred it to all the justices, and the conservative majority on the Supreme Court didn't rule in President Trump's favor like they did in some of the other cases, like the NLRB case, the Wilcox case, and the Boyle case, which was another similar case. I think what's really notable about the Lisa Cook case is that the Supreme Court really is viewing the Federal Reserve differently than it is other agencies. And we already knew that from the Wilcox decision in May, where the Supreme Court said that the Federal Reserve is unique. It has a unique structure. It has a unique history. It's really quasi-private, according to the justices, and therefore it's not like these other independent agencies which the conservative justices seem to view as more clearly falling under the executive branch.
And there was no dissent. So now the court is going to hear arguments in the case challenging Trump's firing of FTC Commission member Rebecca Slaughter, as you mentioned. That's in early December.
Right.
Does the schedule for the Cook case suggest that the justices want to look at the FTC case before turning to the Fed?
Yeah, I think that's a fair reading. I mean, I think the issues are a little distinct, right? I think the FTC case really is going to concern whether for-cause removal restrictions are constitutional or not, and whether the Humphreys Executor Supreme Court case from 1935, which established that they are constitutional, should be overruled or not. That's really what's at issue in that case. This case, the Lisa Cook case, almost presumes that the for-cause removal restriction is constitutional. And the issue is, what does cause mean? What does it require? And, should there be notice and opportunity to be heard? And who should even make that determination as to whether the for-cause standard has been met?
And the Trump administration here, the Solicitor General, said that Trump had reason to fire Cook for cause. He also said the courts don't have the discretion to review the president's determination.
Right. That's the government's argument that, A, the for-cause standard is very broad. All it requires is something beyond a policy disagreement, and that it's really up to the president to determine whether that standard has been met. You know, Lisa Cook obviously takes a different view and says, well, if it's only up to the president to determine whether the for-cause standard has been met, that essentially renders the standard meaningless because you've turned it almost into an at-will standard, which should not be the standard at all.
For those few people who may not have heard about these mortgage investigations, Trump has accused Cook of mortgage fraud, which she denies. She has not been charged with a crime yet. And Bloomberg News has previously reported that loan documents for Cook's Georgia home appear to contradict the claims made by the FHFA chair, Bill Pulte. So this is at a very early stage. How did the federal judge who reviewed this look at it?
I think you're exactly right. This is all at a very early stage, and so they're really trying to determine what the law even requires before they get into the facts of the case. The trial court judge essentially held that for cause can't solely be based on something that happened before the person was appointed to her current role. If it is something that happened before she was appointed, it has to at least tie into her ability to serve in that role, and that hasn't happened here, according to the trial court judge. And the trial court judge also said that there has to be some sort of due process, according to the Constitution, and that wasn't satisfied here either. The appeals court ruled solely on the due process argument and didn't even get to what for cause requires. And so, you know, the Supreme Court, we don't know exactly how far they're going to go. We don't know if they're going to rule on both those issues. I'm sure they're going to explore both those issues, but they may, like the appeals court, wind up ruling just on, you know, whether due process is required. And they may say, you know, if they agree with the appeals court, they may say due process was not satisfied here. And, you know, they'll send it back to the lower courts, or they'll articulate what due process actually does require, and then send it back to the lower courts to determine whether that standard was met here or not. So it is early, as you say. After the Supreme Court rules, most likely it will go back down to the lower courts.
And did the Trump administration claim that there was notice to Cook because of social media posts of the president?
Yeah, their initial argument is that notice and opportunity to be heard isn't even required here because there's no property interest in a public interest role like the Federal Reserve Board governor seat. But their argument after that is, okay, well, if notice is required, it was satisfied here because President Trump's social media posts gave her ample notice, and she had ample notice to respond to those posts, and she hasn't really substantively articulated why the allegations are wrong. But, you know, I think her approach is a sensible one in the sense that, you know, she's saying, look, the law requires more than that at a minimum. And so let's argue about what the law requires before we even get into the facts here.
And in this case, you had a group of former Fed and Treasury officials who served under Republican and Democratic administrations writing a friend of the court brief that urged the justices to leave Cook in place?
Right. These are amicus briefs, like you said, from former Federal Reserve Board governors appointed by presidents of both parties, as well as Treasury secretaries appointed by presidents of both parties, arguing why Federal Reserve independence is so important. And they just point to a more stable monetary policy in countries where you do have Federal Reserve Board independence. This, again, goes to the point which I think the Supreme Court already picked up on previously in their Wilcox decision in May as why the Federal Reserve is different from other independent agencies that more clearly fall under the executive branch.
And, Elliott, you are giving Cook a 60% chance to prevail at the court?
Exactly. I think she's a slight favorite based on what we've seen the Supreme Court do in the Wilcox decision and what we sort of have seen it do more recently in Justice Roberts not issuing an administrative stay, and again, in all the justices not doing what they did in these other cases where they allow determinations to take effect while the case plays out. But it is a close case. There's a lot of unsettled issues like the ones we've talked about. What is cause? What does it require? Is there a due process requirement? What kind of notice is required? And who should make that determination?
It's a high-stakes case, and the oral argument should be interesting. Thanks so much, Elliott. That's Bloomberg Intelligence Senior Litigation Analyst Elliott Stein. Coming up next on the Bloomberg Law Show, President Trump has already sent troops into Los Angeles and Chicago over the objections of the governors of California and Illinois. Oregon isn't waiting for the deployment of troops. It's already suing Trump over what it says is an unlawful federalization of the National Guard. I'm June Grasso, and you're listening to Bloomberg.
There is no insurrection. There is no threat to national security, and there is no need for military troops in our major city.
The next city to see the National Guard on its streets will be Portland, Oregon. In a post on Truth Social on Saturday, President Trump said he was authorizing troops to, quote, protect war-ravaged Portland and any of our ICE facilities under siege from attack by Antifa and other domestic terrorists. But the state isn't waiting for the deployment to push back. It's already suing Trump over what it says is an unlawful federalization of the National Guard. Here's Governor Tina Kotek.
Any deployment would be an abuse of power and a misuse of federal troops.
My guest is Leon Fresco, a partner at Holland Knight and the former head of the Office of Immigration Litigation in the Obama administration. Leon, is this similar to what happened in Los Angeles and Chicago, where Trump deployed troops over the objection of those cities' mayors and the state's governors?
Well, it's similar in one respect, and it's different in another respect. The Los Angeles operations first started off as much broader National Guard operations, basically trying to keep the peace in Los Angeles due to conflagrations that had happened as a result of ICE enforcement at various Home Depot and other type of locations. Whereas here in Portland, there is that type of rhetoric, but at least the discussion of it is basically only about sending 200 Oregon National Guard troops to protect federal facilities. And so the federal facility protection part was actually viewed as lawful in Los Angeles when that occurred. What was not viewed as lawful by the federal courts there was the larger protection that didn't involve the protection of federal facilities. And so even though there's now a lawsuit that's been filed by the Oregon Attorney General seeking to block the federalization of the National Guard, at the end of the day, the ICE facilities, at least according to the Los Angeles order, appear to be something that the National Guard can be deployed to protect because it is a federal facility. But we'll wait and see where this goes because there's other issues at play also. The city of Portland is claiming that ICE violated its land use agreement with the city of Portland by detaining individuals for much longer than they were supposed to be detained, and other issues with regard to how far these protests are being blocked by the National Guard agents. Are they just protecting the facilities, or are they going further out than that? And so all of those things will need to be resolved in a federal court proceeding later this week. The preliminary injunction hearing is supposed to be determined later this week, but for now, we're going to basically see, can the Guard be deployed at all? Most likely, the answer will be yes, to protect the federal facility. But then there will be questions about, again, is ICE violating the terms of its land use agreement with Oregon? And are these federal troops doing more than just protecting the federal facility?
So do you think that Oregon officials jumped the gun by filing a lawsuit now instead of waiting to see how the troops are deployed, whether they just guard the ICE facilities or whether they engage in policing?
Correct. You would normally want to build a better record in a situation like this, but I do think that at this stage of things, there's a lot of politics involved, and so people just want to get these lawsuits in, and then they'll sort of let the facts come as they may, which is not normally how you would do a lawsuit, but in these days, where everything is politics. There's all of these questions. Was the National Guard mobilization motivated by politics? Was the lawsuit motivated by politics? And so there's politics on all sides here, and we'll just have to wait and see what the court, who is not supposed to be a political actor, does about all of these various claims that are being made. And also one further complicating fact generally is that in civil litigation right now, in cases involving the government, unless there's some threat to life or liberty, those are being continued right now because of the government shutdown. And so unclear if these hearings will go forward if there is a shutdown that continues for some period of time.
Have Illinois or Chicago sued over the deployment there?
They sued with regard to the way that ICE is enforcing both at the immigration courts and with regard to grant funding, but not with regard to the National Guard.
So many lawsuits, very difficult to keep track of them, but you do.
Yes.
So now you had a judge, a Reagan-appointed judge with 40 years' experience on the bench, write a blistering decision finding that the Trump administration unconstitutionally targeted non-citizens over their speech about the Gaza war. Tell us what Judge William Young in Boston, what he found.
Sure. So the case is called the American Association of University Professors versus Rubio, and it's a question about the policies that the administration was putting in place with regard to saying basically if you support Hamas in your rhetoric on social media, et cetera, that you would, for foreign policy violation reasons, be deportable from the United States if you were not a citizen. And so the people who sued in that case said this was ideological deportation that violated the First Amendment. So that was their claim. And the Trump administration was saying that the deportation was not based on political speech or pro-Palestinian views, but really at the end of the day was based on support for terrorist organizations, aka Hamas, and national security concerns, meaning that if people were sort of riling up tensions in the United States who are foreign nationals, so they're not U.S. citizens, they're foreign nationals, engaging in dialogue that's meant to rile up tensions, why is that in the national interest of the United States? Better that, people like that not be here so that there's less quote-unquote tension being riled up. And so this is the sort of the debate, and the issue is who wins in this situation. Does the First Amendment win? As long as you're not doing any actual violence, if you're just advocating on behalf of the Palestinians, and let's say even if it's a pro-Palestinian solution to the conflict, is that protected, or can the administration, based on the broad authority given to it by the congressional statute, say, look, the statutes say when the Secretary of State finds any conduct bad for the foreign policy interests of the United States, the Secretary of State can order a deportation. So who wins in that fight? And what the court said was that this was First Amendment, plain and simple discrimination. It was designed to intentionally chill protected speech, to create an environment of fear regarding pro-Palestinian views so that people wouldn't voice these opinions because they knew they could get deported if they voiced these opinions. And so the court said that that was unacceptable, and that what needed to happen moving forward is, because it would violate not just the First Amendment but the Administrative Procedure Act, is that there needed to be clear guidelines on whatever is and isn't acceptable, that would be what could maybe potentially be implemented in a future case. And of course, those clear guidelines could be challenged. But this idea that the Secretary of State could just, without any warning, find speech not acceptable and revoke your visa without any clear guidance, he viewed as unacceptable and violative of the First Amendment. And then there was a lot of course, very high-minded rhetoric about the First Amendment and democracy and protection of rights, etc. But at the end, this is the basic framing of the opinion. And so now, of course, it will go up to the First Circuit and then the Supreme Court to try to figure out what's actually going to win in this battle between the First Amendment and the rights of people to speak in America about views, whether they're views that are popular or not popular, as long as they're not actually doing anything else other than just speech, versus the Secretary of State's rights under the congressional laws to, if you read the text of those statutes, pretty much order anyone deported that he thinks he should for the purposes of protecting U.S. foreign policy.
Yeah, so how much of a setback is it for the administration to its claim that the Secretary of State has the authority to revoke visas and green cards under this rarely used provision?
It will be a major, major problem if the higher level courts say that statute as written is too vague to be constitutional, or that the way it's being applied is nevertheless too vague, meaning perhaps if you put some policies with regard to a specific form of conduct, then maybe you could apply it, but just without warning, sort of having this catch-all that you don't know if you're going to get caught in the catch-all, that might be too vague. So I think this has the potential to be a dramatic setback for the Trump administration and the Secretary of State, but we'll need to see some higher courts doing this at the end of the day, because just the district court decision alone isn't going to ultimately change the outcome of these cases. So once these cases get appealed and get to the Supreme Court, that's where we're going to wait and see. But if this ruling is maintained, it would be a dramatic alteration to the policy that the Trump administration was trying to put in place, which was to say, if you're not careful with, the things you're saying in the United States while you're here and you're not a citizen, you could subject yourself to deportation. So better to just be here and be like a polite guest in someone's home, where you don't say anything about anything controversial when you're visiting someone's home. You just kind of have your cake and your wine, and then you go home.
Cake and wine. I like that combination.
Yes, exactly. You just say, how's the weather outside? It's 80 degrees. It's lovely. That kind of thing. And that's pretty much the extent of what you should be doing here if you're not a U.S. citizen.
And in this 161-page scathing ruling, the judge directly and sharply criticized President Trump and his immigration policies, saying they were intended to strike fear into non-citizens and chill freedom of speech.
Look, the judge was very unhappy with the Trump administration. The judge was very unhappy with the arguments that were being made about non-citizens not having the same First Amendment rights as U.S. citizens, which, by the way, is a undecided issue in federal law. I would not say that that's a decided issue. And in fact, the last real decision on that, which was a 1952 case called Harrisiadis versus Shaughnessy, which had to do with membership in the Communist Party, went against the First Amendment rights of foreign nationals. And so from the standpoint of thinking that it's a slam dunk that foreign nationals have the same First Amendment rights as U.S. citizens, that's not exactly true, and we'll need to see how the court deals with it. But nevertheless, this judge just thought that this was being implemented in a way that was just unconscionable to the court, and so the court definitely in those 160 pages decided to express itself and its frustration very openly, and was putting, notes in that the court had received in the past and writing notes back to people. It was very personal, obviously, decision for this judge. And so we'll wait to see if the appellate courts think that makes it more or less persuasive moving forward.
And I've never seen anything quite like this in a judge's opinion. At the start of the judge's opinion, before the title of the case, it began with words taken from an anonymous postcard threatening the judge that had been sent to him in June. And it was a duplication of the note in this block printing. Quote, "Trump has pardons and tanks. What do you have?" And then the judge typed his response beneath it. "Dear Mr. or Ms. Anonymous, alone I have nothing but my sense of duty. Together, we the people of the United States, you and me, have our magnificent Constitution. Here's how that works out in a specific case." And then the opinion followed. Does that change the way an appellate court will assess this decision?
I think the problem is this. all of the federal judges grow up reading these great decisions written by other judges where, you have a learned hand or a Judge Posner who put some rhetorical flourishes in cases, and people said those are the famous judges, and they make their mark, and so every judge wants to add rhetorical flourishes to their case. And, sometimes the judges are very upset. This judge was clearly very upset here. I think personally, not that I want to be a judge anytime soon, but if I were a judge, I think the most effective judges are the ones that do not make it look like in any way they're taking any of this personally, and they're just basically printing out a decision the same way ChatGPT would do it, or, Microsoft Copilot or something, very impersonal, but just to lay out the facts. And when somebody reads those in an appellate court, they say, wow, that's a very thoughtful judge. Clearly this judge was just trying to get it right. Those decisions tend to have much more deference given to them than the ones where there are these larger rhetorical flourishes. Although, when you survive them, if you get those decisions upheld, then those do become the famous decisions of all time that get cited to students and people read them. So it kind of is a gamble, but this is why those types of decisions get issued.
So we'll keep watch and see what the First Circuit thinks of this opinion by Judge Young. Stay with me, Leon. Coming up next, after a 4-year freeze, Dreamers will be able to submit DACA applications again. I'm June Grasso, and you're listening to Bloomberg. About 500,000 so-called Dreamers live and work in the United States without fear of deportation. That's because of the Deferred Action for Childhood Arrivals program, or DACA. First launched in 2012, DACA offers protections from deportation and work eligibility to immigrants known as Dreamers who arrived in the U.S. as children and were no older than 30 when it was set up. Legal battles over the Obama-era program have stretched back to the first Trump administration's attempt to end the protections. DACA has been closed to new applicants since 2021 while litigation played out. But now, in order to comply with a court order, federal immigration officials have revealed plans to reopen the DACA program to new applicants. I've been talking to immigration law attorney Leon Fresco of Holland Knight. Leon, tell us how we got here.
So here's what happened. So DACA has been under a nationwide injunction because of a lawsuit filed by the state of Texas in the U.S. District Court in Brownsville. And so the idea was we wouldn't ever get back to DACA ever again until the Supreme Court finally was going to decide once and for all, is DACA legal or not? But in the birthright citizenship case, which we've also talked about, the Supreme Court, although it didn't decide the birthright citizenship issue, that issue is going to come up now, the court did say you can't have a nationwide injunction. Well, guess what happened? The state of Texas, in the case of Texas versus the administration, now Trump, but before Biden, that the state of Texas had a nationwide injunction against DACA. Well, you can't have a nationwide injunction. End of story here. So the U.S. government has agreed you can't have a nationwide injunction. The Texas court cannot have a nationwide injunction. There's going to be a hearing again later this week, depending on the shutdown. So if the court goes forward with this hearing, even the federal government has said that the injunction can only basically apply to Texas, which means for the other 49 states, there will have to be a process that reopens up sooner rather than later, where foreign nationals who are eligible for DACA can now begin to ask for DACA again. What will be very interesting to see is how many people actually do come forward, knowing that if DACA is invalidated, then they become sitting ducks, quote unquote, in the sense that the administration would say, oh, well, thank you for applying for DACA. The court has viewed this to be illegal, but thank you for letting us know where you live and where you are. And so now you're in deportation proceedings. So that's the risk people will have to take. But by the same token, if people get protected by DACA, and if the Trump administration doesn't want to eliminate DACA, then presumably they might actually end up being here legally. So we'll have to wait and see. You have not actually heard a ton of rhetoric from the Trump administration talking about deporting people who are in the DACA program. You've definitely heard it about the people who came during the Biden administration. But remember that anyone who is on DACA was someone who was here since at least 2007. So from that standpoint, we're talking about almost 20 years that these people have been in the United States and they came as kids. You have not actually heard the Trump administration talk about deporting these individuals. And so it is possible that this program, if it is determined to be legal, might not be eliminated by the Trump administration. We'll have to wait and see.
But the first Trump administration did try to eliminate DACA, right?
Correct. They did try to eliminate DACA, and the Roberts Court said at that time that the manner in which they tried to do it was unlawful. But this court, this Trump administration, has basically been letting the court cases travel as such. And while it definitely hasn't done anything to help the DACA recipients, it hasn't tried to scuttle them in the kinds of ways that you might think it might try to do in terms of individual revocations or going to people's houses or things of this nature. So we'll just have to wait and see. I'm not saying that there couldn't be an order coming anytime that says, look, we've changed our mind on DACA and we want it all gone. But at this point, what they've said is the injunction should be limited to just Texas, and we understand we're going to need to reprocess people's DACA cases again. And so we'll have to wait and see what happens from there.
So at the end of June, there were more than 525,000 people enrolled in DACA. Nearly 88,000 of them live in Texas. So Texas Dreamers are not covered by this. So they're going to have less rights than Dreamers in other parts of the country. How does that make sense?
Correct. I mean, that will be a problem, but that actually has happened a lot in immigration law. So, for instance, there are decisions to this day where if you live in the Ninth Circuit, the law on asylum will be better for you than if you live in the Fifth Circuit. So that does exist in these contexts until the Supreme Court harmonizes something nationwide, which sometimes they do and sometimes they don't do. Never is it usually this disparate in the sense that you can actually qualify for a document in one state and you cannot qualify for a document in another state. That's a very rare scenario that's happening now because of the nationwide injunction issue. But what's interesting is the way addresses work for the purposes of immigration forms is you're not tied to Texas for the rest of your life. If you legitimately move and you occupy a residence in another state as opposed to, actually lying about your address, you can't do that. You cannot lie about your address. But if you were to move to California or wherever, then you might actually be eligible for those DACA documents, even though you were originally in Texas. So people will have decisions to make there as well.
So now this is the oddest deportation case I've heard of. I'm sure you've heard of ones that are even more unique. But the Des Moines school superintendent, Ian Roberts, is resigning while he battles his federal case for deportation. He was arrested by ICE agents in connection with a previously unreported final order of removal an immigration judge issued in May of 2024. He was hired as the superintendent in May of 2023. I'm curious as to how that could happen.
The way basically these things happen is there's a bunch of, I would say, identity issues in the immigration world. But the only one that really matters is whatever identity you have that's tied to your actual fingerprints in life. And so this individual, Ian Roberts, has an identity as a Guyanese non-citizen. So he's not a citizen of the United States. He's from Guyana. And that this individual, Ian Roberts, with these fingerprints, has a final order of removal because this Ian Roberts did not show up to court. And so when you don't show up to court, you have a final removal hearing. Now, there's a person also called Ian Roberts who claimed in his immigration paperwork that he gave to the Des Moines public schools that he had resolved his immigration issues and that he had legal status. And so the school didn't run him through what's called the E-Verify system, which is the system that basically from the Homeland Security Department can tell you once and for all who is the person you're dealing with. They didn't do that. They used what's called the simple I-9 form document, which is the only thing you're actually required to do as an employer. The E-Verify is an extra thing you can do, but the I-9 paperwork is simply the person fills out the paperwork and they give a driver's license and a social security number, and if they do that and they claim they're a U.S. citizen, then end of story. The employer really can't do anything about it if that person gives you a driver's license and a social security number and says they're a U.S. citizen. So the point is that that's the belief of what Ian Roberts told the Des Moines Public Schools, and so that's why they hired him, and that the school system didn't do a further investigation on this. And so now Roberts resigns from the school board or from the school system because this order of deportation ends up getting executed against him. And Roberts is saying, I thought I had fixed my situation, and he's going to try to make that argument in immigration court. But I don't know how likely he is to prevail here.
And Leon, before I let you go, the Department of Justice has just announced the creation of a new office within the Civil Division that has implications for immigration. So there used to be 5 branches. What now?
There was an immigration branch, was the branch I was the head of. There was a federal programs branch. There was an appellate branch. There was just a normal civil litigation branch and a consumer protection branch. That consumer protection branch has been eliminated, and it's been replaced by something called the Enforcement and Affirmative Litigation Branch. And what's interesting is that the Affirmative Litigation Branch is basically going to be used to sue states and cities about both immigration and about transgender issues. And so they're basically going to be looking across the country for, are any transgender sports or other type issues, or any sanctuary city, or any scholarships being given to foreign nationals that are not being given to citizens, or anything like that. And they're just going to be scouring the waterfront looking for any person to sue, or any, official, or any city, or any state that they believe is violating the laws with regard to both immigration and with regard to transgender issues.
New priorities for this Department of Justice. Thanks so much, Leon, as always. That's Leon Fresco, a partner at Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.